We're going to call a meeting to order. Just I'd like to introduce the board members. If you could each speak in the microphone, just introduce yourself.
Jim McKelvey.
John Barney, Council of the Board.
I'm Jeff Williams, Chairman of the board.
My name is Kevin Hudson. Kevin Hudson. And Kurt Bedford.
What I'm going to do now is introduce our attorney, our counsel, to set some ground rules and protocol. John Party is going to just take a few moments to explain to everyone what's going on.
Thank you all for coming. This hearing has been convened for the purpose of adjudicating an appeal from a zoning certification letter issued on January 17, 2014 by the City of Newark's Director of Planning and Development, wherein the Director concluded that, based upon information submitted by the Data Centers LLC, a gas-fired combined heat and power plant qualifies as a permitted accessory use for a data center in the Science and Technology Campus Zoning District, because on-site power generation is, quote, customarily incidental and subordinate, end quote, to the proposed data center. Two appeals from the zoning certification letter have been filed, the first by Sherry Hauffman, Esquire, on her own behalf, and the second by Kenneth Crystal, Esquire, on behalf of 5 individuals and 2 organizations. This proceeding, although open to the public, is not a public hearing, but rather an adversarial proceeding, much like a trial before a court of law. Accordingly, no public comment will be taken, and instead the board will hear presentations from the parties to the appeal, namely the Appellants, the City, and Data Centers LLC. In accordance with the board's standing rules of procedure and pursuant to a March 5, 2014 stipulation among the parties, the board shall hear first from the City and Data Centers LLC, each of whom shall be accorded 45 minutes and no more than 90 minutes combined to make their presentations. Thereafter, the board shall hear from Ms. Hauffman and Mr. Crystal, each of whom shall likewise be accorded 45 minutes each and no more than 90 minutes combined to make their presentations. If the members of the board should have any questions during the presentations, they should feel free to ask the questions at that time. At 9:15 p.m. or thereabouts, the hearing will be closed and the board shall then deliberate and render an oral decision, provided that no decision of the board shall be final until the same is reduced to writing, approved by the board, and filed with the city secretary. The board is presently comprised of 4 members, as the 5th member of the board has previously recused himself due to a potential conflict of interest. Accordingly, 3 votes shall be required in order to carry any motion, provided, however, that in the event of any stalemate, the decision from which appeals have been taken shall stand. The chairman of the board shall preside over these proceedings. Any witnesses called by any party shall be sworn before presenting their testimony, with the exception that lawyers who are members of the Delaware Bar need not be sworn. All those present tonight who wish to observe these proceedings are certainly welcome to do so, provided that outbursts of applause, booing, heckling, or other disruptions will not be tolerated and will result in removal from the hearing room. Out of respect for the parties and the board, we ask that observers remain quiet and maintain a respectful demeanor at all times. Mr. Chairman, that concludes my remarks.
Then we are ready to hear from the appellees, first from the City of Newark.
Good evening, members of the board. Can you hear me? No. Let's try a different microphone. My name is Max Walton, and I represent the City of Newark, and I have represented the City of Newark as special counsel since around 2006. On behalf of the city, I thank all members of the board for your service on this important case. As board members, you provide a great service to our city, and I'm sure this matter has taken you away from your normal lives, as you probably spent countless hours pouring through the hearing materials, and it's a mountain of them. I can tell you without hesitation, having represented state, county, and municipal governments for many years, of for the past 14 years specifically, is the most detailed set of submissions I have ever seen in the Board of Adjustment Appeal. So, to start, as you look out in the crowd behind us, you see hundreds of people, both for and against the data center proposal. This is not a popularity contest. First the city, and now the board, must make a decision on the law, not based upon some mathematical count of who is for and who is against the project. Taking the law and the applicable facts into consideration, it is clear that the city's zoning verification should be affirmed. It is clear that the proposed on-site power facility, known as a CHP, which I'm going to call a CHIP for short, is an accessory use to the proposed large-scale data center because the facility is customarily incidental and subordinate to the data center use. Now, let's talk about our format just for a minute for today. I only have 45 minutes to state the city's case, and this is a pretty expansive record. And in an effort to condense things, and hopefully to assist the board with wading through the amount of materials, I'll give a 20 or 25-minute presentation by PowerPoint, and I will withhold 15 minutes for the rebuttal at the end. Members of the board, please understand that in this format, there is no way I can touch on all the arguments that have been made. So I'll have to rest on our papers or what was written in our brief if I don't touch anything today. And I'd like to start with an effort to help the board, because as I read through the materials submitted, it became clear to me that an explanation of how the CHP or the chip works might be in order. So, if you don't mind, members of the board, I'm going to point you up here. I'm going to try to give you some of the terminology that is used in all these papers and try to explain it to the best of my ability. First, the first term is IT critical load. And before I get started, let me preface this. This chart is directly attached to the zoning verification, and it's a chart which was relied upon by the city when it made its zoning verification, and it was submitted to the city by TDC. So, with that being said, some of the key terms are IT critical load. Now, what is IT critical load? That is the amount of power that the computer facilities or the computer cubes, servers, modules, whatever you want to call it, that's the power they're going to use. And if you look at the chart, there's a phase 1 and phase 2, so it goes across. What is ancillary load? Okay? Ancillary load, that term means that's the additional power that is needed for the facility itself, for heating, cooling, running the place. Okay? Now, the next term is redundant capacity. And so I can explain that. Redundant capacity is, and I'm going to call it, for lack of a better term, additional power that's needed by the data center so that the computer facilities don't go dark. Okay? And so it's a little bit more, as you can tell, than the ancillary load plus the IT critical load. Right? Maintenance capacity, which is called the M+1. That maintenance capacity is power that's available, but it's cold. It's not running at the time. And then the operating capacity required, which in our briefs is called the required operating capacity, if you look at it. That figure, okay, is essentially the IT critical load, the ancillary load, and the redundant capacity. So as we go through. So let's talk about the chip and how it works, so you guys have familiarity. This is just a phase 1 depiction of the chip, and it's based upon the chart that I just had up there. In phase 1, there's going to be 1, 2, 3, 4 running gas-fired turbines, which have a capacity of 23.2 megawatts each. Okay, now how a CHP or chip works is these turbines are hot. They create steam. They create byproduct. That hot or that steam, that byproduct, is used to power what they call the steam turbines down here. Okay? So in other words, these guys are the running ones, and then they power, simplistically, the steam turbines through the waste product. And then we talked about the standby capacity, reserve, maintenance capacity. This is what's going to be installed in phase 1. So I hope that gives you a better understanding of how a CHP or a chip works. Okay? Now, I tried to sort through all this material, and I tried to come up with what I believe are undisputed facts, because there's lots of them, lots of facts that were put out there. But I believe these are undisputed. Data centers must have power at all times, because the servers can never stop running, right? And data centers are electric hogs. I don't mean to use that term, but they use a lot of power to make sure they're running. And the other point is that the loss of power for a data center, even for a very few seconds, can cause damage to the servers, and it can cause severe financial consequences. And just so we're clear, Mr. Engel, we submitted his affidavit, and he is one of the leading data center designers in the United States. He's designed over 1,500 data centers. It's also confirmed by Mr. McCann's affidavit. And again, we do not believe these points are disputed. So this is where we start, okay? And I thought, since it's in the paper, it's a lot, and then talk about M+2, I'll go over M+2. M+2 is the power needed by the data center, right? Or the required operating capacity. It's more power than the computer servers use, but that extra power is used in case one of the turbines would go down, or they would have a power failure or a mechanical failure at some time. This M+2 configuration is used in virtually every data center, and it's been around, this kind of configuration has been around since 1994, so and the internet just turned 25, so it's been around for a long time. All right, so the zoning official's job was to first determine whether or not the principal use was a permitted use, okay? And the principal use is the data center. And again, there doesn't appear to be any dispute that data centers are permitted uses in the Science and Technology Zoning Center District, right? And there's the language from the code, okay? So, what is the proposal at issue here? The proposal is for a 900,000 square foot data center on 43 acres on the former Chrysler site. So, I tried to give you guys some benchmarks about how big that is. That's 3/4 of the size of Christian Hall. That is a lot bigger than a football stadium. And here's the point. It's still permitted because there's not a size limitation in the Science and Technology Center Zoning District. It's going to be on 42 acres. But I want to get across that this is a really big facility. All right. Why we're here is because of the question of accessory use. And that's what this hearing has been brought out. Accessory uses, again, it's undisputed, accessory uses are permitted in the district. And the code defines accessory uses as those that are customarily, incidental, and subordinate, right? You guys heard that a lot of times in the papers. The key term to this is the use. The use needs to be accessory. So, the parties have tossed out all kinds of different definitions of what it means to be customarily incidental. And they're up there, and I just cut them out of the different parties' briefs, and I put them up there for you to see. Ultimately, it doesn't matter which of these definitions you pick, because on-site power generation is customarily incidental to a data center use. And it's commonly long-standing practice, and we list here just a few of the examples that are in the papers where on-site power generation, and that can be either backup power or primary power, is a customary use. So, now, there have been arguments that have said that the data center use is not, or excuse me, the CHP use is not customary because all data centers, or most data centers, do not have a CHP in association with them. The argument is usually data centers have backup power, right? But if you look at the definition of accessory uses and the way courts have interpreted accessory uses, even if the use is only associated with a small percentage of the primary uses, it still is accessory or customarily incidental. So let me give you some examples that courts have found. And I have cases if you guys need them. But for example, a tennis court has been found to be an accessory use to a residential facility. Why is that? Well, obviously, everybody doesn't have a tennis court in a residence, but it's a use that's customary doesn't mean that it happens with every single residential property, but it's a customary use. Another example is churches. Churches have been found, churches who have daycare centers as an accessory use. Certainly every church doesn't have a daycare center associated with it, but that has been held to be an accessory use. And as far as a chip goes, there's the Citizens Coalition case. And in the Citizens Coalition case, which is cited in the papers, and cited in my earlier memo, and it's attached to the zoning verification itself, it makes clear that a CHP was found to be a permitted accessory use for Georgetown University, even where they sold power. So my point is, you can't, as the appellants have done, is do a mathematical count to determine whether or not a CHP is an accessory use. You just can't. You have to look at whether or not it's customary incidental. And it is. Okay? In 2007, the EPA identified 14 data centers with a chip. There's a bunch of other examples that we have, and you guys have seen those in the papers. Right? So one of the other things that has been said, the chip isn't customarily incidental because it's too big. That's one of the arguments. It's too big. The other CHPs are smaller than this one. You have to correlate the size of the CHP to the size of the data center. Excuse me. This is a 900,000 square foot data center building, which will be built in two phases, two 450,000 square foot buildings. And TDC claims it's going to be one of the largest data centers in the country. And Mr. Engel, just so you're aware, backs that up. He attaches a chart to his affidavit, which he showed the average size of data centers. And this one is literally off the chart. I didn't even put it up here because of that. Because this is a very large data center, there has to be a corresponding size to the power generation facility. And so it's not too big for the data center. Your job is to look at it and find out if the use is customarily incidental. Right? We will concede that the other chips are smaller in size than the proposed chip. But under Delaware law, and this is the case the appellant cite, and this is what they follow, it makes it very clear that each accessory use case must be decided on its own facts. And the bigger the power generation, or the bigger the data center, the bigger the power generation required. So the chip is customarily incidental. One of the other claims that have been made in this case is that a chip is not customary because usually data centers have backup generators, diesel, that kind of thing, which they use as their backup power for their N2 or the required operating capacity. All right, and I just thought that we ought to take a look at what that would entail for this particular data center. If you had to generate 170 megawatts, you would need at least 68 2.5 megawatt cat generators, which are the big ones, the biggest ones I could find. And that would require thousands of battery backups. Because if you're familiar with generators, what happens is the generator starts, power goes out, the generator then starts, but there's a delay. So you have to have batteries to carry you over to make sure that there isn't any period where the data center is without power. And TDC estimates, and the city doesn't know for sure, but we know based upon general calculations, that it would take 12.5 acres of batteries. 12.5 acres of battery to have enough battery backup for this data center. So that's a ton of generation, backup generation. And I would submit that it would be actually bigger than what's going to be built now. The chip's operating hours is another question that was raised in the papers where appellants have talked about the operating hours because the chip runs longer than backup facilities, therefore it's somehow different. But they haven't cited a single case that holds that. There's not a single case that I've been able to found that the length of time that the use runs determines whether or not it's accessory. Again, your job, the city's job, is to determine whether or not the use, the on-site power generation, whether or not it's customary, and the overall hours of operation are going to factor into that. Now, I do not have a slide about the claim that there was a like to use this coffee cup to demonstrate my point why a patent pending doesn't matter. And this is a coffee cup that my colleague got from McDonald's. And if you read the top of the coffee cup, it says, right on the top, patents pending. What that means is that this coffee cup may in and of itself be, or this coffee cup lid may in and of itself be unique, but the use of covering up the coffee so you don't spill it on yourself is common or habitually associated with the coffee cup. So ultimately, the idea that because there is a patent pending that makes the process here unique, that's not the case. You have to look and see whether or not the chip and the on-site power generation is customarily incidental to the data center use. So, the city has read the cases and believe that you identify customarily incidental, and that phrase, they really go together. It's customarily incidental. That's the test. Appellants have said, well, we'd like you to use a different definition for the word incidental. And they say it's non-essential. They say if you look at the definition in Webster, it says non-essential. That's only one of possible definitions, right? And they haven't cited a single case in the entire country that holds that for use to be incidental, it must be non-essential. And in fact, under Delaware law, defines incidental as having something that is a reasonable relationship or connection with the primary use. And guess what? That comes right out of the Widener case that they say. So the bottom line is, you do not have to be incidental. To be incidental, you do not have to be non-essential. And no court does not have that. So the last prong in the test is subordinate. It has to be customarily incidental and subordinate. Right? Here, I think we can all agree that the dominant use is the data center, because the data center requires a massive amount of power. And the power which supplies the chip, obviously, most of the power being used is going to be used by the data center and part of the data center's need. All right? And why do they have that need? They need constant, uninterruptible power. And that's constant, interruptible power is in the form of extra power or spinning reserves that keep it. So, for example, if one of the turbines goes down or breaks down or there's mechanical failure, the other ones immediately fill in without delay. That's the required operating capacity from the N2 that we discussed earlier. And if there's any question about that, Mr. Engel's affidavit, Mr. Vitelli's affidavit, both make that case. No matter what, data center needs to have extra redundant power. So, but for an accessory use, we agree, I think the appellants in the city agree, that the use cannot be the dominant use of the property. This CHP cannot become a commercial power plant under any set of circumstances. So, to assure that this use is always subordinate to the principal use, e.g. the data center, the city, in its zoning verification, made a limitation. They said that extra power that you're going to be producing, but not actually using, which is part of your need, you can sell it. But that's got to be limited to 30% of the required operating capacity. All right? And what did the city do, right, to make sure that the CHP, or the chip, was always subordinate? If you look at the zoning verification, the city said only 30% can be sold. TDC is not allowed to start selling power until the first client has entered the data center. Again, so that there isn't a power plant running without the primary data center use. The power plant, or the power sales have to be phased. In other words, you can't build a chip all the way out at the very beginning to maximum capacity and only have a little bit of the data center. They have to be phased. If ultimately the required operating capacity turns out to be less, let me tell you why that's important. Because this zoning verification is sort of the first stage in the regulatory process, so we don't know for sure, absolute sure what the ultimate power need is going to be. If it turns out to be less, the corresponding amount of power that can be sold must go out. And what did the city do to make sure that it remains subordinate? It monitored power generation and sale numbers so they didn't exceed that 30% threshold. So ultimately, I don't think there can be any question based upon these additions that were placed on the CHP by the zoning official that the chip is excuse me, that the chip is supported. So, I think it's pretty clear that the chip is customary, incidental, and subordinate to the data center use under these specs. But we have to go to the neighborhood. And there is a definition of neighborhood. It's in the city code, which says an accessory use cannot impair the neighborhood. Really, if you think about impair the neighborhood, it has three elements, right? There must be an impairment of the neighborhood where the accessory use exists. There must be an actual impairment of some kind. And that impairment must be objective instead of subjective. In other words, there actually has to be a harm that occurs. And merely because I believe that there's going to be a harm that may occur is a subjective belief. But an actual harm has to be there for impairment. All right. So let's take the first prong and figure out what the phrase "the neighborhood" means. And we have a dispute over this. And appellants say that the phrase "the neighborhood" should include surrounding neighborhoods. That's not what the code says. The neighborhood means it's a single neighborhood, not tons of neighborhoods or the surrounding neighborhoods. So I'm sorry about the small print, but probably one of the things we came up with, we had a dispute about the definition of what the word neighborhood meant. So I used the appellant's definition of neighborhood. Up here, it's their exhibit 245. You see that? And if you look here, this is what they want. This is how they want you to interpret the word neighborhood. The quality or state of being immediately adjacent to or relatively near something in proximity, the neighborhood of the earth to the sun. That makes sense. Think about it. How much? I want to buy my car from you. How much is it going to cost me? Well, that's going to cost you in the neighborhood of $10,000. That makes sense. But when you're talking about a residential neighborhood, that's not the right definition. So let's use their definition, right? And it's number 4, okay? And it means a relatively small section or district, okay? And that's one definition, right? Kind of the phrase here when they describe it says the whole neighborhood would hear about it, right? So it's a limited definition. Another definition, a particular section of the district that is lived in by these people and that is marked by individual features. That's types of homes, public establishment, together to give a distinctive appearance or atmosphere, right? Everybody knows what a neighborhood is. I live in a neighborhood, and we talk about that a lot. So let's talk about what the neighborhood is here. And this is I believe this map was attached to the appellant's, excuse me, not the initial appellant, but the appellant's file. And it talks about the neighborhood, or it talks about what uses are around. And if you guys are aware of this, this is the old Chrysler site. And this is the Amtrak line. And there's a storage in transit yard here that Norfolk Southern keeps where they have tanker cars and other things that go along. That goes up. This is Route 4, what I call Route 4. And this is also 896 that goes in front of the stadium. Okay? Now, the contention here is that if you look at the plain meaning of the definition of neighborhood that we just said, this is a huge neighborhood. It's a Chrysler site. It's bounded by definitive characteristics, and this is what the neighborhood is. And you guys remember what this neighborhood was. You guys are local, and that's the Chrysler site. And that's the neighborhood that was there until 2008. And that's what this neighborhood looked like back in 2008. All right? And this is what the neighborhood looks like today. I make a left on Elkton Road and come over to Route 4 to take my son to school every day. And I pass by exactly this photo, which is the city yard. And that's the back side. And if you look, on all the pictures I'm going to show you, this is the water tower, the old Chrysler water tower, which everyone's familiar with. And that'll be a point of reference. So over here, this is Bloom Energy buildings that are on site. This is kind of over by where the Amtrak yard, or where the Amtrak passenger station is, excuse me. And if you look at the back, this is the picture from along the same line of the tanker cars that are parked out there. That's the neighborhood. It's the STC zoning district. All right? There is no allegation, and no one in the Star Campus District, or the Star Campus, which, to be fair, includes STC's own a little piece of manufacturing, or in the I district. None of those neighbors, they are the neighbors that are here. Okay? The appellants here do not have standing, or they cannot bring a right to claim because they don't, to say that the neighborhood is impaired, because they don't live in the applicable neighborhood. So, next, let's talk about the second problem. Remember we talked about impairment, right? And the alleged harm is that the neighborhood in the vicinity are harmed by this use, okay? And they are just generally air pollution, noise ordinance violation, loss of property value, and emotional distress. You can read the city code pretty hard, but actually if you look very closely at the City of Newark's comprehensive plan, it says that DENRAC deals with air quality issues. I think that's pretty clear and I think that's undisputed. And DENRAC has a detailed set of air regulations that must be followed, and they're adopted pursuant to the Clean Air Act, Federal Clean Air Act. All right? The point is, whether something's correctly zoned has nothing to do with whether or not DENRAC or EPA air quality standards will be met. Right? And if those standards are met, it's my contention that for air emissions, there is a neighborhood impairment because the law has been set. As I stated from the beginning, the law has been set what you can and cannot do. So what the appellants are asking you to do is they claim that even if those standards are met, the city should deny zoning verification, the initial step anyway. They should deny the project. Well, it's disturbing to me that we're all here in this contentious thing. And I certainly don't mean to offend anyone. But DENRAC has submitted an affidavit in this case. And he says that, and DENRAC, it's Mr. Foster, who works in the air quality section, and he said before any air permit can be issued, all air quality standards need to be met. There have to be a net air quality benefit. So what the appellants say is, that's not good enough because DENRAC's not going to follow the law. That's what they said. So, that contention has to be rejected for several reasons. First, there's a presumption that a government agency, right? The government agency who's represented by the Attorney General's office has to faithfully execute the law. That's a presumption. And if they don't, there's an appeal process. It doesn't come to this board, it goes to the Environmental Appeal Board. But the idea that ultimately that the city council and the city would allow air standards not to be met, the city has taken the unprecedented step in this case. They hired their own air consultant to make sure that all DENRAC standards are met, all clean air standards are met. While there is a concern about air quality, and it is a concern, it's not the basis to deny zoning verification. So the next is noise. Talk about noise. And we say, again, right, I think it's pretty plain law that if all legal standards are met, something cannot be denied, right? And the appellant's contention is that the ambient noise standards might be too high so you could be able to hear noise beyond the property line and it would be audible. How do we know that at this point? How can the city know that? Because it's got to be audible beyond the Amtrak lines and Norfolk Southern lines. And here's the other point. There are features, sound deadening features, that will be put in during the construction phase, which we haven't even gotten to yet. So we do not know right now if there will be sound outside the building that's audible. And if you look at their expert, they say, look, if it's 52 decibels, you can hear it outside. If it's 52 decibels in the property line, you should be able to hear it on down the road. We don't know if it's going to be 52 decibels at the property line. We don't know. It hasn't been built yet. We can't tell. And that should be a basis, that potential, that air quality laws, that noise laws will be violated. The potential for that to happen isn't a basis to overturn the zoning verification. Home values. I have represented this city very proudly for a certainly wouldn't want to advocate for anything that would allow home values to go down, right? But ultimately, we don't know, again, if home values will go down. There are conflicting affidavits in the record, and I submit to you that the city should not have to go out every time there's an accessory use and hire an appraiser to try to figure out if home values will go down. But the bottom line is that under Appellants theory, that if you're going to have air emissions from a power plant, the value numbers will go down, right? Well, if that's indeed the case, when Chrysler closed, the property value should have gone up because you didn't have the emissions going on. But guess what? We had an economic downturn, so we don't know what's going to happen. Everybody knows that the Chrysler closing, that there was no tremendous increase in home values. But here's the point. The theoretical possibility that home values might decrease is not a basis for the denial of a zoning verification, which otherwise meets all standards of proof. All right. Members of the board, the city's job first, and now your job, is to apply the law that's written. And the claims of neighborhood impairment at this stage of the game are speculative. There is no conclusive proof on this record that overall air quality will be reduced. There's no conclusive proof that there will be any reduction in home values. There's no conclusive proof that the chip will be audible beyond the property line. So, my point to you is you should make an objective determination, not based upon what one might think that might be a line. You should make an objective determination. And if you make that objective determination, you look and you see that for you to make your decision here, you have to determine if the chip is customarily incidental and subordinate to the primary use, which we established at the beginning it was. So, just to sum up, I thought I'd give you what the law said, and what the Delaware Supreme Court said, because what I said at the very beginning was, it's our job to make sure that the law is followed. That's our job. This is a popularity contest. All right? The city and the board are required to apply the law regardless of an individual's preference, right? And individual land use decisions, there have been 3 of them. I'm sure council knows these decisions well. Applications that comply with the law cannot be denied outright. That's one. That's rule 1. If there's ambiguity in the zoning law, it must be construed in favor of the free use of land. And 3, idiosyncratic treatment of property owners is not something that's permitted. And if you think I'm kidding, here are the cases. Coney Ashburn says you can't make, you may have to prevent development based upon non-code and related ad hoc determinations. Ultimately, in this case, denying an application with fully comply with all provisions of the code, Kent County exceeded its statutory power. So if you are customarily incidental and subordinate, you need to be approved. This is a case that really gets under my skin, because I'm going to tell you why. Because I argued this case on behalf of the Board of Adjustment for the town of Dewey Beach, and I lost. And I argued that it shouldn't be, the statute shouldn't be construed in favor of the landowner. And the Delaware Supreme Court said that any doubt must be resolved in favor of the landowner when making a land use decision. That means if there's ambiguity in the meaning of any term in the land use ordinance, like for example, the term neighborhood, it must be construed in favor of the free use of land. Finally, going to Gibson versus Sussex County, this is an opinion that was written by our now Chief Justice. He was not Chief Justice at the time. He said that the singling out of particular owners for idiosyncratic treatment is not acceptable. And the fact is that in all the papers, no one has cited to any decision by the city at any time where we denied zoning verification based upon non-code factors. So let's put it all together. The plain meaning of the definition of accessory use, the city correctly concluded that the chip is customarily incidental and subordinate to the data center. And we already talked about the theoretical possibilities, right? And if there was any doubt in your mind, under J&K LLC, it makes clear that you need to defer to the zoning officials' determination if there's doubt in your mind because of the interpretation of its own code. So ultimately, because this use is customarily incidental and subordinate to to the proposed use, the zoning verification should be affirmed. I'm going to reserve my remaining 10 minutes for rebuttal. Thank you.
Mr. Walton, you have please, the only detracts from the proceeding and delays this from being over. So please hold your applause or other outbursts until later. You have 10 minutes remaining, Mr. Walton. Are there any questions from the members of the board, Mr. Walton, at this time? If not, then we'll hear next from Mr. Forsten. Thank you. Mr. Forsten, before you get started, I believe one of the members of the board does have a question for Mr. Walton.
I just wasn't sure the procedure we were waiting to the end to address questions, or whether we address questions right now and does it take over your time?
You should ask questions now, and unfortunately, yes, there's no other way to manage it. We'll have to take from their time.
Good evening.
How are you, Mr. Hudson?
Doing well, how yourself? I have questions. I'll make this quick for you. The roads that were projected for use, the city.
I'm sorry, Mr. Hudson.
Oh, sorry. The power usage, the city conditioned it on a 30% threshold.
Correct.
That is based on the projected output and projected use of the facility, correct?
The required operational need, that's correct, yes, which includes the use plus the necessary remaining power, correct.
My question is, under Wiggins, it's decided based on the facts of a particular situation. It seems here that they are projected uses, not necessarily what's going to be used at the instant moment. And I was wondering if you could
Yeah, that is kind of correct, if you don't mind me saying that. There are projections based that have been provided to the city as we stand here right now. And those projections are what the city based its 30% number on. If you read what the city did, these power sale numbers aren't locked into that. It says up to 30% of the required operational need. So if it's determined later that the required operational need is less, corresponding power sale numbers will go down as well. So in other words, it's an initial projection that's up to, it's not, and I think it's very clear in the zoning verification letter.
Another question is, what is the position on why 30% is the critical amount?
Yeah, if you look in, I gave you Ms. Phoebe Roser's affidavit and the reply submission, she goes through how she came to the decision of 30%. And it goes through, and I don't have that here, but it's in there. She goes through the different sections of the code. She was trying to apply legislative intent, essentially looking at the different sections of the code where there's 25 or 30% limits. Now, you can say subordinate, at least in theory, could be up to 49%, right? It's 1% less than 50. And again, she went through the code and tried to determine legislative intent. There wasn't a percentage on this particular accessory use, but you look at the other ones and determine 30% was the appropriate number.
Let me ask, what is the city's position on when does the power sale threshold, when does it become a dominant use?
When it's no longer, when it becomes the primary use of the property. When power sale numbers exceed the 30% of the required operating capacity.
I understand that's the condition the city placed on it, but when does it actually, regardless of the city's condition on it, when does it become dominant?
In the commercial power plant scenario, for example, if you had a, for example, if the city just said, this year's zoning verification, and this is a, I'm sorry, I'm trying to talk. Pardon me. In the commercial power plant scenario, if there wasn't a data center that was being built, and there wasn't a required operational need of the data center, For example, let's say that the CHP or the chip was built and the data center shut down for some reason. It would be the primary use of the property would be the sale of power, even if that 30% limitation was on it. So that couldn't happen. That is precisely why that the limitations are put into the zoning verification. We say that it has to be tied to the data center need.
Mr. McKelvey's question.
Mr. Walton, do I understand, is it your position that the on-site power generation, which is customary in this particular case, is to produce island mode, or that it is not, in fact, different in kind or in extent or nature from all the other examples of on-site generation which are used just for backup?
There is a difference, and there is a difference, to be candid. If you look at the other data centers that are out there, certainly the large majority of them are not going to use the term island mode. They have some connection to the grid. This one does not. It's an island mode. But that's not when you're looking at accessory use. That's not what you look at. You look at the actual use, the power generation, on-site power generation facility. And, for example, whether or not the chip would be an accessory use doesn't change if there were, for example, a line that came in and that some power was used for the grid or used for backup. You're still using the same use for the data center.
Thank you. My second question is about impairment to the neighborhood.
Yes, sir.
I understand the documents that have been provided, that air quality that's required by the state has to do with the ability of a polluter to buy credits from elsewhere to make this thing balance out. And my question is, does the fact that this installation will produce emissions that are above the permitted amount and only becomes legal by virtue of its credit law, does that not in fact still net, does that still net out as damage to the neighborhood?
I'm no expert on the Denmark process, so please bear with me my understanding of that process. The idea is because Newcastle County is in a non-attainment zone, you have to buy those, because Newcastle County is in a non-attainment zone, you have to buy back credits not just equal to what you're going to do, it's got to actually increase. And actually, if you look at and I can pull the citation for you, if you look at some of the affidavits that were submitted by the real estate experts that appellants have, they say, look, that doesn't really factor in because that emission is up really high. So in other words, you have to factor in the region as a whole, so to speak. So to answer your question, yes, there needs to be credits that are purchased. Denmark has said there has to be a net air quality benefit as you go through the process, and that's the process that they have.
Thank you, Mr. Walton. You have 2 minutes remaining.